Important aspect of why you need independent regulators and you need specialized tribunals that will hear appeals from the decisions of these independent regulators. Independent regulators, whether it is in the United States or in the United Kingdom or in Europe or in India, often tend to get captured by the sectors that they regulate. They tend to look at issues only through the prism of the problems faced by the entities that they regulate. Therefore, the need for independent appellate tribunals that will hear appeals from these regulatory decisions. And as I said on the last occasion, the new regulators are more like the headless fourth branch that you have in the United States. They combine aspects of legislation, that is, they make delegated legislation, they implement the mandate of the act and of the delegated legislation that they make, and at the same time adjudicate upon issues raised out of the implementation. To hear appeals from these regulators, therefore, is no mean task. High Court judges, and I find even the Supreme Court, to which all appeals go from these tribunals, simply don't have the time to appreciate the nuances created by these regulators. And that is a problem I'll come to in a moment. The bigger problem with both the regulators and the specialized tribunals that hear appeals from them is the lack of qualified personnel who understand these areas. As in many other cases of regulators as well as tribunals, that is the traditional tribunals that are covered by 323A and 323B, these specialized tribunals have also become happy hunting grounds for retired bureaucrats, mainly the civil service. They simply don't have the expertise to deal with these areas. And without naming particular tribunals, I must tell you that I've heard these specialized tribunals sometimes say from the bench that we are not qualified to appreciate the nuances of the decisions made by the regulator against whom we're hearing appeals. We will simply proceed as though we are in the 226 jurisdiction or the 227 jurisdiction, hearing issues related to jurisdiction, to natural justice, etc., but we won't substitute our opinion for those of the regulator below. Now, even though the Supreme Court has been at pains in cases involving the TDSAT, etc., to confirm that these are expert tribunals that can hear every aspect, including the substantive merits of the regulator's decision, many of these appellate tribunals are unable to function in that capacity because the retired bureaucrats who have come to staff them are not experts in that particular area. A second aspect associated with this, of which I spoke on the last occasion, because retired bureaucrats come to staff these tribunals, there is some level of government interference in the functioning of these tribunals. That is to say that civil servants still have contact with the bureaucrats who staff the relevant government ministry, the administrative ministry, that is concerned with the sector in question. So independence becomes a problem. Another aspect is the efficacy and efficiency of these tribunals. In many cases, for example, the debt recovery tribunals and various other tribunals, including the mines tribunal, which is solely within the province of the administrative ministry, that is the Ministry of Mines, they are unable to dispose of cases which remain pending before them for years and years. Mr. Arvind Athar, who has been fighting cases in the Supreme Court, including the Madras Bar Association decision of the Constitution Bench and the more recent National Tax Tribunal issue, which came before the Constitution bench in the last couple of months, is firmly against tribunals in general, because he says that they, in a sense, carve out and remove from the jurisdiction of the traditional courts, that is the civil courts as well as the high courts, the subject matter completely, and because they are dominated by the civil service without any qualifications. Having said that, all that I can say is that we can't afford to throw the baby out with the bathwater. The fact of the matter is there are many tribunals, including the Electricity Tribunal, which are doing an excellent job in this area. The Competition Tribunal has been trying in the last couple of years under Justice Sirpurkar as well to do a much better job of dealing with these new competition law issues, and also airport regulation, because the same tribunal also handles the appeals from the Airport Economic Regulatory Authority. There is another example, of course, which is the National Green Tribunal. The Supreme Court had long ago spoken of the need to have a National Green Tribunal with experts that would handle environmental issues. And that tribunal has gone to the other extreme by substituting itself completely for the high courts as well as the Supreme Court, that is the 226 jurisdiction and the 32 jurisdiction. In fact, they have come out with a couple of recent judgments that are now before the Supreme Court concerning their power to, in fact, engage in judicial review of all delegated legislation. They've also claimed the power to issue what amounts to a writ of mandamus to the central government to protect particular areas in the country against environmental harm, even if the delegated legislation in question doesn't provide for it. And as you know, they have stopped mining, for example, of minor minerals across the country on the ground that they don't have environmental clearance and so on. Therefore, you have some tribunals such as the NGT that are possibly too effective in terms of taking over powers that possibly were not intended to be conferred on them. I think, therefore, that the whole issue of tribunalization of justice is a mixed bag. There are some tribunals, including in the area of taxation, consumer protection, etc., debt recovery, that are unable to function very well and have simply become swamped to the point where, for example, in the case of debt recovery tribunals, the SARFAC has been introduced to permit the banks to take over properties without recourse to a process of law, such as before the debt recovery tribunals, which in turn took over this area from the civil courts. And on the other side, you have specialized tribunals that are functioning reasonably well. I would say, therefore, that apart from service law tribunals and 323A tribunals, where they have simply become an extra layer, the specialized tribunals, especially in the economic regulatory context, are absolutely necessary in order to ensure that important sectors of the economy do not get bogged down by being stuck before the high courts and subsequently the Supreme Court. In the case of the 323AB tribunals, in fact, after Chandrakumar, their entire purpose has been defeated because the Supreme Court has said mandatorily that all these issues must go to the High Court. On the other hand, if you look at the specialized tribunals, where an appeal is provided directly to the Supreme Court, by and large, although the High Court's jurisdiction is still there, the constitutional jurisdiction under 226 and 227 remains, the High Courts follow the rule of effective alternative remedies and relegate people back to the specialized tribunals or to the Supreme Court in terms of appeals. Having said that, I would say that even in these cases, the problem of expertise still remains, both in the specialized tribunals as well as in the Supreme Court, which hears appeals from them. Long ago, I believe the United States Supreme Court said that the Constitution of the United States did not enact Herbert Spencer's social statics. In other words, social scientific theories are not part of the court's jurisdiction as such. The truth of the matter today, however, is whether it is the US Supreme Court or the Indian Supreme Court, they make policy. In making policy, they pretend that they are simply applying the law. They set up committees, etc., take recommendations, and either accept or reject them, depending on the particular philosophy of the judges hearing the case. That doesn't resolve the problem of lack of expertise, however. The truth of the matter is that when judges make policy, underlying that policy, they have a particular social and economic philosophy. That philosophy, however, remains a silent premise that is not exposed to scrutiny, but it needs to be. And I would suggest, therefore, that one of the weak links in our system of specialized tribunals, especially in economic regulatory areas, is the fact that Supreme Court judges and High Court judges must take the time to acquire expertise in these specialized areas so that they don't come to it without the requisite underlying knowledge. I think that concludes my talk today. I think I have given you my ideas on most of these issues, and I'd be happy to take any questions that people have afterwards. Thank you.
Thank you, Krishnan. And now I request the next speaker, Mr. Koka Raghava Rao, who is sitting to my right, reminds you all, such of us oldies, Koka Subbarao, who was our very revered and respected Chief Justice. I don't know whether he is anyway connected with him.
Yes, I am from his office.
Oh, he is from his office only, he said.
From Madras.
Madras. So he has been in the profession for 62 years. And I thought that I am the oldest in this one. No, he is 87. I'm much junior. May I request Mr. Rao to address us for the next 10 minutes or so, something?
Mr. Bhat, Mr. Venugopal, and ladies and gentlemen. When Mr. Bhat mentioned yesterday that he is 10 years older than the retirement of the judges of Supreme Court. Then in that contest, we had a discussion and he asked me and I revealed that I am 87. That is how it has come. Friends, you see the subject for discussion in this session is, are tribunals merely adding one more layer to the court system? And if that is so, what would be the more effective alternative working paper? Straight away, I would like to give the answers first and then go to the discussion next. See, I don't agree with anybody if he says that the tribunals have utterly failed to serve the purpose. They are also doing some work under the Arbitration Act and other acts, Lokata and all that. And it is not satisfactory, only I can say. Secondly, I am having number of suggestions as effective alternatives. Particularly, I am for maintaining these courts, but with amendments for the speeding up of the procedures. That's how I am answering the subject. See, this administration of justice in our country, in this court system, commenced about 300 years ago when the Britishers introduced this system as it was in their country. And these procedure courts have also come into force more than 100 years ago. And several amendments are carried out, and even recently twice the civil procedure is amended, but the suggestions which now I am making are not touched at all. So I am particularly, yesterday, my Lord the Chief Justice was mentioning that in the recent survey it is revealed that there are about 30 million cases pending in all the courts in India. And in particular, in Supreme Court itself, 65,000 cases are there. Yes, every day we have been seeing cases 10 years old, 11 years old, then 15 years, and even 20 years old cases I have seen coming up for final hearings. But whatever it may be, now we'll have to see, rather find out some alternatives. See, for that, the amendment of the procedures I would suggest. The law is an instrument for socio-economic progress of the society, and the legal profession has to share the responsibility. At this juncture, a new look and a fresh approach in the need of the day to restore the confidence of the common man in the judicial system. The system of judicial administration of our country requires restructuring to make the rendering of justice more effective, at the same time speedy and less costly. Particularly, laws delays have become proverbial, leading to denial of justice, as avoidable delays are not avoided in existing system of administration. All of us know the civil suit is commenced by the presentation of the plaint in the court. And it will be put to scrutiny in the registry, and there the delays commence. For processing it and to numbering it and giving a date, they are taking weeks and months together. In my submission, when the plaint is presented, then and there, the person who presents the item must be called upon after giving SR number to sit there and complete if there are any defects and number the plaint that day itself. And the same day, the summons can be sent to the defendant, also fixing a 30 days time giving to him, directing, see, along with, yes, first insistence should be that the plaintiff, while presenting the plaint, he must file the list of documents and the list of witnesses on whom he is going to rely upon. He cannot file it and go on imagining and collecting the evidence and cooking up evidence and all that. Then, while giving the notice to the defendant, within 30 days, along with the written statement, it must be insisted that the defendant also should file the list of the documents and the list of the witnesses on the first date of hearing itself. That is, within 30 days, entire process will be over. The plaint is there, along with the documents and the list of witnesses, and the written statement is also there with the list of documents and the list of witnesses. Then the next step, all of you know about it. The civil procedure is code with a purpose. It is amended and section 89 is introduced. The idea of introducing section 89 is very good. That is, the court, the wording in the section, it gives first option to the court. If it appears to the court that there exists an element of settlement, then he can refer the matter to one of the things, that is arbitration, or arbitration under the Arbitration and Conciliation Act, or Lok Adalat under Legal Service Authorities Act, or C for judicial settlement before some suitable institution or a person to be a Lok Adalat, and D for mediation. And these are all the systems made available. But what is happening is, in 99% of these cases, this process is not serving any purpose, practically. And while referring, the court also should suggest the terms of, the court must formulate the terms of a possible settlement. Then it's already narrowed down. And that purpose is not served by introduction of section 89, and there must be elaborate amendments regarding that also. So the issues can be framed straight away. Instead of that, they will be posting the matter for draft issues, and again issues by the other side, and then the court will have to, it doesn't need so much of time. Then, when we come to the stage of the trial, the evidence of those witnesses can be recorded, and it must be from day to day continuous. By that, the court will be also there in advantageous position. I'm mentioning all this about the trial court, because the delay commences at the trial stage. Then, after the evidence is recorded, the matter can be posted for written arguments. It must be insisted. By written arguments, it will be advantageous to the advocate also. He can cover all the points he wants to cover and exchange the written arguments, and 4 weeks time may be granted to them for that exchange, and any rejoinder arguments also.